Order granting ex parte application to continue trial and finding regarding excludable time periods pursuant to Speedy Trial Act. Okay. Smash that like button, hit that subscribe button, man. Yeah, I never knew why the celebrities want to be good in the hood. Straight up. I never knew that. Why do these celebrities need to be good in the hood? I just never understood that, man. Listen, I don't want no validation from nobody in no damn hood. I don't care what nobody in no damn hood think about me. Straight up. I think when you get the mind state and you come from there and you elevate, and I could go back if I wanted to go anywhere. But I don't want no validation from no niggas in the hood. Fuck, I need you to validate me for. Fuck out of here. Need you to validate me to make me feel better. That shit don't pay the mortgage around this motherfucker. You know what I'm saying? You validate me in the hood. That shit don't put no gas in the car. And that shit don't pay my insurance. Shit don't pay electric. Don't pay motherfucking gas. That shit don't pay none of that. No niggas validating me in the hood. You know what I mean? Hell no. I like to do what I want to do. Hey. Yeah, man. I guess when you've been around it for so long, maybe you look at it a little different when you get to understanding it. And I think, you know, some of these people, they really ain't been around it. You know, they might have had some time with some people around it, but they really ain't been around it. You've been around it, man. I don't want that shit around me. Straight up. Let me see here. Let's see what they say with Big U shit, y'all. On April 10th, 2026, defendant Mark Martin and Sylvester Robinson, along with attorneys of record for defendant Eugene Henley Jr., collectively with Martin and Robinson's, the moving parties, filed an ex parte application for continuance of the trial date in action. The application asks that the trial be continued from May 5th, 2026 to February 16th. So now the trial date is February 16th, 2027. Yeah, I mean, the court cites documents by the page numbers added by court ECF system rather than any page numbers that appear with the documents negatively. The matter came on for hearing on April 17, 2026. At the hearing, the moving parties argued they needed additional time to prepare given inter alia the complexity of the action, the nature and volume of discovery produced by the government. Man, y'all hear that shit? The nature and volume of discovery. That right there means that it's a lot of shit in there, man. This don't mean that Big U is in good hands, man. They said the nature and volume of the discovery. That means it's a lot of shit. This is why they asked for a continuance. And Big U and the co-defendants want this shit to be pushed back. This ain't the government. The government was ready to go. But it's a lot of shit that they need to go over that they trying to fight. So I don't want people to confuse that part. You know what I mean? Straight up. Recently, additional discovery disclosures by the government, the need to conduct further investigations in trial preparation, and delays in payments to counsel appointed pursuant to the Criminal Justice Act. They got new evidence, and they also, the lawyers need to be paid. Straight up. Some attorneys ain't been paid, and they got new evidence that they added to the discovery. Martin and Robinson are on pre-trial release awaiting trial. Co-defendant Eugene Henley Jr., who is detained pending trial, opposes any further continuance of the trial date, as he has throughout the action. The remaining 4 defendants, including co-defendants Termaine Ashley Williams, who is also detained pending trial, supports the request for continuance of the trial date and submitted all trial conflicts. All defendants are currently represented by court-appointed CGA counsel. Nobody has a paid lawyer. Okay. So, can we be honest? You think that any of these people have a chance of beating the case with a court-appointed attorney? If we just being real. You think that they have a chance of beating the federal government with court-appointed attorneys? Come on now. The moving parties have made a sufficient showing of diligence for the courts to grant further continuance. The government investigation underlying this action spans several years, and the discovery is in this action is voluminous. Man, they got a whole bunch of stuff, man. It's a whole bunch of stuff. Even excluding documents, the government has indicated it will not offer during its case in chief at trial. There are at least, hold up, 591,741 files of discovery. Man, that's a lot of discovery, man. Come on, man. Come on, man. Okay. All right. Okay. Some of which contain multiple lengthy audio video files under one batch stamp. Okay. All right. Okay. The government has disclosed an additional 24,918 files of discovery since the court January 6, 2026 hearing on previous motions to continue. So from January 6th to April 17th, they produced 24,918 files of discovery. Come on, man. Come on, man. Can we make this make sense together, man? You think they produced 24,918 files and they don't have no evidence? Oh, man. Okay. All right. Okay. All right. On March 25th, 2026, the government provided defense counsels for all defendants with a 23-page preliminary exhibit list. This list out approximately 311 exhibits. Defendants in this action have collectively filed 16 substantive pretrial motions totaling more than 1,000 pages of brief and several motions in limine. The moving parties contend a lack of continuance would result in ineffective assistance of counsel. Now, they all want a continuance, man. Everybody wants a continuance because they need time to review the evidence, right? The feds was ready to go. It says it right there. The moving parties contend a lack of continuance would result in ineffective assistant counsel. They're saying that if they do not get a continuance, that they will have ineffective assistant counsel because they don't have enough time to review all the damn evidence. Okay. They further contend that due to the sheer scope of the discovery review and adequate preparation for trial is an impossible task in the current time frame. They don't have enough time. Counsel have worked together to split up tasks and cooperate with possible and provided the court with the in-camera attorney declaration details what work that has been done to date and why more time is needed to complete specific outstanding tasks. The court hereby finds that the application, which the court incorporates by reference into this order, along with the representation of counsel at the hearing and in their sealed declaration, demonstrates facts that support a continuance of trial date in this matter and provide good cause for finding a excludable time pursuant to the Speedy Trial Act. So the court is making sure that they don't violate the speedy trial rights of the defendants. And they're making sure that the defendants are the ones that want to continue this case and reschedule it so that they can't come back and say that their speedy trial rights was violated. Okay. The court further finds that the case is sufficiently complex due to the number of defendants and the nature of the prosecution, including the volume of discovery that has been and is expected to be produced, that it is unreasonable to expect adequate preparation for pretrial proceedings or for the trial itself within the time limits established by the Speedy Trial Act. The end of justice served by the continuance outweighs the best interests of the public and the defendant in a speedy trial. The failure to grant the continuance would be likely to make a continuation of the proceedings impossible or result in a miscarriage of justice. The failure to grant the continuance would unreasonably deny defendants continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation. Taking into account the exercise of due diligence and any delay as to defendant Henley is reasonable, as he is joined for trial with co-defendants as to whom the time for trial has not run and no motion for severance has been granted. Hey, listen, man, they got a lot of evidence in this case. Straight up. They have a lot of evidence, man. You think that they got 500,000. Hold up, matter of fact, let's say 600,000 because it got 24,000 extra. You think that they got 600,000 pieces of evidence and they ain't got no case? 600,000? And nothing in there is gonna say that they guilty? Come on, man. It's your boy DZ, man. It's your boy DZ, man. Okay. All right. Therefore, for good cause shown, the court grants the application. The trial in this matter continued from May 5th to February 16th. The pretrial conference is continued to February 3rd, 2027. Come on, man. All right. Smash that like button, hit that subscribe button, man. This your boy DZ, man. The time period of April 10th, 2026, the date the application was filed, to February 16, 2027, inclusive, is excluded in computing the time within which the trial must commence pursuant to 18 USC. All defendants are ordered to appear before this court at the United States Courthouse, 350 West 1st Street, Los Angeles, California, on February 3rd, 2027 at 10:30 a.m. and on February 16, 2027 at 8:15 a.m. No waivers of appearance shall be accepted for either date. Nothing in this order shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods are excluded from the period within which trial must commence. Moreover, the same provision and or other provisions of the Speedy Trial Act may in future authorize the exclusion of additional time periods from the period within which trial must commence. It is so ordered. Understanding this right here, man. The government is giving Big U time to review the documents. The sealed documents are going to be sealed. They're going to let Big U see what they want him to see. They're not going to allow Big U to get the paperwork. Big U has to fight for his life with a court-appointed attorney. Out of all these people that Big U knew, the celebrities, the stars, nobody put up a bag for his attorney. He knew major celebrities. Nobody's helping him out. Nobody's putting no money up saying, here, we want to look out for you. Make sure you got an attorney. Everybody in this case is going with a court-appointed attorney, man. Man, ain't nobody beating shit. Straight up. Ain't nobody beating nothing, man. All this evidence, and you got court-appointed attorney. Understand this, right? Understand this. These people are being paid. The attorneys, they're being paid by the government, man. They don't care about these defendants. They're only doing their job. We've been ordered, as an attorney by the government to represent these individuals because they can't afford counsel. We don't care about them. Why would we care about them? We go home every night. The attorneys probably think they guilty any damn way. Come on, man. It's hard for you to fight a case when you got a court-appointed attorney and you don't even get to see the evidence. You don't even get to hold the evidence. So, and I'm going to tell you, being honest, right? When you got a case, you need to look at the documents over and over again to find certain things. You have to sit there. And I'm telling you, the last time I had a case, I had to watch the video surveillance 50 times at least to find where the police went wrong. In order for me to beat the case, I had to read over everything so many times, right? And the attorney that I had didn't want to give me the paperwork. Just what they doing to Big U, I had an attorney that I hired, that I paid for, telling me that I couldn't see the stuff. Trying to railroad me, right? Then I got a public defender after I fired the attorney because I didn't want to get another attorney because I understood that they were playing games with the attorney. So I got a public defender in the situation, got the public defender to say, if you do not give me my discovery, I'm going to write the Bar Association on you and the prosecutor for not providing me my discovery. I get my discovery because I forced a hand and I beat my case. But Big U's situation, he's incarcerated. He's locked up. The feds playing games with him. He don't got that kind of mouthpiece because he's inside of the system. This is their game. When you playing their game, they play their game their way. It's what everybody got to understand. We can say, we hope Big U beat it. They ain't got no evidence and the case is this, that, and the third. But when you are in their system, they have control of the case. You don't have no control. And then you ain't got no attorney. You sitting around expecting them. You can't even take your stuff to the law library and sit there for 8 hours and study. You don't got that opportunity to sit in the law library and just go through your paperwork back and forth to try to find a loophole. They do this shit on purpose so that you don't have an advantage, so that you are off balance. Yes, the attorneys are going to try to do what they can because it's their job, but do they care? No. No, they don't care. They don't care if Big U beats it. It's not like they looking for rep off of beating Big U's case. They were forced on the case by the government. Government assigned them. They taking that work. You know, attorneys sign up for that shit. They sign up to be court-appointed lawyers. And they get picked when they get picked. You know, they do the same shit in the state. You got some lawyers that, you know, got their own practice, but they sign up to be, you know, public defenders. And when, you know, it's conflict of interest or something, they'll appoint one of the attorneys to one of the defendants because it's a conflict of interest in the public defender's office. So they give them a private attorney. You know what I'm saying? Hey, listen, man, it's a dirty game. Straight up. I'm just being real. It's a dirty game, and, you know, they can say what they want thinking Big U gonna beat this shit. You know what I'm saying? I'm willing to bet whoever, you know what I'm saying, that he's not gonna beat it. I'm willing to bet whoever. He can put it on the table. You know what I mean? Because I know he's not gonna beat the shit. Ain't no way they got 600,000 pieces of discovery and they just think he gonna beat the case. Hell no. You know? Yeah, he can get found not guilty of one charge and get found guilty of 10 charges. That ain't beating the case. Straight up. And then when they say they got video, they got audio, they got surveillance, they got witnesses. Come on, man. But what they don't want to do, and I'm going to tell you this right now, right? They don't want to violate any of his due process. Because they know if they violate the due process, then he got a chance of an appeal. And I'm going to tell you like this, right? Because I found this out last time I had a case. If the government or the state has witnesses that are confidential informants. Now, this is foul. I'm not saying that this is correct. This is foul that they do this, but this is how they got the law set up. If the government has confidential informants and witnesses and shit like that, they don't got to give you the discovery. That's ill. You don't get to possess it. Now, that's foul. And I had to learn that. I didn't even have no confidential sources or witnesses in my case, and they was trying to play that shit on me. I said, hold up. I'm the only one on the case. What are you talking about? They tried to pull it on me. I'm the only one on the case, and they said I couldn't get my discovery. I'm like, nah. Shit, I went to trial for murder and I got my discovery. So you mean to tell me I got this punk charge right here and I can't get it? And I went to trial for murder and I got to see every witness that was on the list, the ballistics, every piece of evidence, and I can't get it for this? Shit. And I went to war and had to fight to get my discovery. Had to fight, had to go to war because they told me I couldn't get it. Straight up, no cap. You hear me? I'm writing the Bar Association. I'm writing everybody. I even filed a damn lawsuit. No cap. Like, nah, how y'all gonna play with my discovery? I know. Contacted other attorneys. Yo, they saying I can't get my discovery. He said, man, you know you got to get your discovery, man. Just keep fighting. They going to give it to you. I'm like, all right. I even wanted to bring that attorney to, you know, vouch for me while I was suing him. And I should have subpoenaed the attorney, but I didn't even want to pull him in it because I knew he had a relationship with the people. And I didn't want him to have to get up there and say the shit. You know, I done beat 3 cases at trial with the attorney. I ain't want the attorney that had to go in there because I already know he got a relationship with them people. And I was like, I ain't even gonna call him, which I should have called him anyway. Straight up. But this is the game that they play. You know, understanding that the system is designed to benefit them. We can say whatever we want and what we think this and that and the third, but it's their game. The hand of one is the hand of all. This is what people got to really understand though, right? The judge, the prosecutor, and the defense attorney, they all go to school for the same thing. They're all lawyers. They're buddies. They're cool. They come out at the same time. Some of them was in class together. It's just one chose to be a prosecutor, one wanted to be a criminal defense attorney, and one said they wanted to be a judge. But they all go to school for the same thing. They go out to lunch together. They hang out together. When court is in recess, they laugh together. It's a game. When you get caught up in their game, you a product of their game. Straight up. You know, now you got to fight for your life. This is why it's important when you are a free person to keep this shit in your mind. You got to keep this shit in your mind and understand that if I get caught up in this game, I'm playing their game now. It ain't no just they gonna play fair. Why would they play fair at their game? Why? They know they control it. They don't have to play fair. It's their game. This is something that, you know, the people got to start understanding this shit. You know, our people really don't be understanding that shit. We start doing shit blatant and don't even give us a chance to fight. Big U was blatantly doing things as if there's not a criminal justice system, as if your homies is not going to tell on you, as if you just going to do it and never be stopped. If he would have started thinking, let me chill, he might have had a shot. The nigga did the same exact thing until they picked him up, man. How you think he gonna have a shot? He did the same thing until they picked him up, man. You know, you got other people trying to, I guess, give people hope for Big U. I don't see it happening. You know, I don't see it happening. And I'm willing to bet any of the podcasters, you know, any podcast, I'm willing to bet any one of them that Big U gonna get rocked. The government knows that this case is public, right? So they not gonna violate his rights to that extent. This is why they doing it the way they doing it. They don't want him to be able to come back because they did something, bam, bam, bam. So yes, they can hold the evidence the way they doing and only allow his attorney to see it. That shit's in the law books. I didn't know it until I was almost going through it. I didn't know it. And then another thing that I learned when you got a case, right? When you got an attorney, you can't say shit. You hear me? When you got an attorney, the only person that can speak for you is the attorney. I tried to file a motion on my own with an attorney. They came back with a rule. I forget what the rule was, and said why my motion was denied and it won't be heard because I got an attorney. I said, oh shit. So now I got an attorney, I can't even speak. When you get an attorney, you can't speak. Your attorney controls everything you say. You got to be quiet. You just there. So think about this. If the lawyer that is your defense attorney, the prosecutor and the judge is all running the show and you don't get to speak and they all cool, how you going to have a shot with a public defender? How you going to have a shot with a court-appointed attorney? I'm just saying. Straight up. How are you going to have a shot to beat a case if all the people that's involved in the damn case is cool, but you the one that's being prosecuted. And they don't want to give you the damn discovery. They don't want you to be able to review the discovery. And we know a lot of these niggas don't understand the shit. A lot of these niggas don't know how to see their case and go look up another case in reference that got dismissed. A lot of niggas don't know how to do that. But a nigga know how to go out in the street and rob. A nigga know how to go out in the street and extort. A nigga know how to go out in the street and sell some work. A nigga know how to go out in the street and commit a crime. But when it comes to what controls that shit, niggas don't know how to deal with it. They don't know what to do with it. They confused. They lost. But everybody know how to break the law, but a lot of niggas don't know how to fight the law. I'm just keeping it a buck. Yeah. You know, and, you know, I come from, you know, with multiple people in my family, we gonna go to war. You know what I'm saying? Uncles, shit like that, done took the feds to war. You know, done won and lost. You know what I'm saying? Like, I come from that shit. You know, if I get in a situation, I'm doing my own homework. I'm not expecting no attorney, no white man to fight my case.